All right, well, I think the time has come. We'll get this event underway. I'd like to say welcome to all of you viewers out there who have chosen to tune in at this particular point in time. Elsewhere, people around the world are watching a reality TV event being conducted to determine the future of the free world. Obviously, those two can debate as much as they like, but here we have people who understand their priorities, and viewers of this particular presentation will have their priorities right. After all, what we're talking about here today is about life and death. So again, I extend my welcome to all of you. My name's Hadyn Oriti. I'm a principal of Donovan Oates Hannaford, and we've been providing legal advice to the community here on the mid-north coast, the beautiful mid-north coast of New South Wales, for 74 years, and I think I've aged particularly well. So today's presentation is essentially about wills and life documents, just as we've advertised. And when I'm talking about life documents, what I'm talking about there in New South Wales are things like powers of attorney, appointments of enduring guardian, advanced care directives, binding death benefit nominations. All terms that I know everybody out there is absolutely familiar with, and so I'm going to be preaching, or at least explaining, things that most of you will probably already understand, or do you? So some of the things that we'll be covering today are wills and why on earth would you bother having one, powers of attorney and appointments of enduring guardian, and what's the point of putting them in place anyway, and then things like the advanced care directive, binding death benefit nomination, and the like. So let's get stuck into this. Why would you have a will? It's a simple question, and the answer is quite complex. But essentially, what a will does is avoids an intestacy. So an intestacy is a situation where you don't have a will and you've died. Now, an intestacy doesn't mean that your assets will go to the government or anything else like that, but the government does prescribe exactly how your estate will be distributed. So why then a will? Doesn't the government get it right? Don't we all put our faith in government? Well, essentially, the government has a formula which is pretty well set in stone about how your estate will be distributed. And perhaps a war story might be a good explanation of why you'd want to have a will rather than allow the government to decide. We had a matter recently where a fellow who was about 90 plus died. He was one of 11 children. He died without ever having married or ever having had any children of his own. But his siblings did have children, and about 4 of them had predeceased him. So when we worked out who was actually going to apply for what's called letters of administration, we had to go through a bit of an exercise to determine who that would be. But then, in order to get the grant from the Supreme Court of letters of administration for his estate, we had to identify all of the siblings, those who died, and then determine who, from those who died, who their children were. And some of those children had then died. And so we went on this particularly intensive investigation to determine who was entitled to share in his estate. This exercise took a very, very long time, close to a couple of years in total. And at the end of it, we were able to get the grant of letters of administration and distribute the estate, which was valued at a grand total of $30,000. So effectively, he probably thought it wasn't worthwhile having a will, given the modest nature of his estate. But at the end of the day, had he put a will in place, it would have ensured that those whom he loved would have avoided the cost, expense, delay associated with following the intestacy rules. So a will, as you'd appreciate, appoints who's going to administer your estate, and then also who's going to receive the benefit of it. And to that extent, wills can be very, very effective, especially if you are concerned about your children, their propensity to spend money, or whether or not their financial status is a little bit uncertain, their habits, who they're married to, and stuff like that. For example, I know from experience that a number of my clients come to me and express concern about the person their child is married to. They're concerned that the marriage may not be strong enough to withstand, the next few years, whatever. They might be concerned that their child has a drug habit or an alcohol habit, on the verge of bankruptcy. Their child might be disabled. And so in those sorts of circumstances, there are structures that we can put in place by way of will. We call them testamentary trusts, which effectively can help secure assets for the benefit of children, and hopefully ensure that the drug-affected child has a pool of assets that they'll be able to draw down appropriately for their living expenses and so on. The disabled child will be able to take advantage of some very tax-effective and also social security effective, by that I mean Centrelink entitlements for disability pensions and the like, structures to support them for their accommodation and care over the balance of their life. So testamentary trusts can be tax effective, probably about the only real tax effective structure that's available in this day and age. They can also ensure that assets are there to use by the children that you or whoever the other party is for the rest of their life. So I would encourage people to perhaps think about their own personal circumstances and consider whether or not structures like that might be applicable. Besides your house, perhaps one of the most significant assets that people accumulate in this day and age is superannuation. It's a common misunderstanding that superannuation will also be governed by your will. It won't. Ordinarily, superannuation does not form part of your estate, and you will need to make separate arrangements to deal with your superannuation. In New South Wales, superannuation will form part of what's called notional estate. That's a concept that's really restricted here to New South Wales, and then in respect of things like when somebody makes a claim for provision from your will because they were dissatisfied or thought that what had been provided for them was inadequate. And we can talk about that later. But in any event, what the point I'm trying to make is that with superannuation, you need to deal with that separately from the balance of your estate. There are things you can put in place commonly, what's called a binding death benefit nomination, whereby you can direct the trustee of the superannuation fund to pay any death benefits from your super in accordance with your directions. Commonly, spouses like to ensure that each other gets the benefit of that, but then they might say that once they're both gone, for example, that it goes to the executor of their will to hold in accordance with the terms of the will. So they're things that you need to consider. I would encourage you, if you are contemplating dealing with your superannuation that way, to make sure that you also speak to your financial advisor before finalising any determination there. So besides superannuation, most people have their house. And a house is generally the largest single asset that they deal with. And by and large, spouses, couples, will hold their house in two forms of tenancy. One is called joint tenancy, the other tenancy in common. Now, these are critical distinctions, and people do need to understand exactly how it is that they own their house. If it's a joint tenancy, then on the death of the first of you, the house will vest in the survivor. So your will have nothing to say about that. The rules of survivorship say that upon the death of a joint tenant, the survivor takes. Doesn't matter what you provided for in your will. So you need to think about the structure in which you hold your house and other areas of your estate as well, joint accounts at the bank, for example. If you have a tenancy in common, then that interest in your property will go according to the terms of your will, which is great. So you will decide, if you don't necessarily want it to go to your spouse, it can go somewhere else, and that's okay too. However, the thing about this is that under the joint tenancy, the property vests in the survivor automatically, and it's a very simple process. Costs very little to give effect to. If you want to dispose of land, your interest as a tenant in common, for example, then it will be necessary to apply for probate. So whilst joint tenancy gives you simplicity and the land vests in the survivor, a tenant in common, your interest in that will go according to your will, but you will need to obtain probate. Probate's no major hurdle, but it does cost, and it will take time to give effect to. So you need to think about how you hold your interest in your real property, in your house, and think about what you might want to do there. So I'll park for the moment the wills. I'll move now to what we call the life documents. And effectively what I'm talking about there are powers of attorney and appointments of enduring guardian. So a power of attorney is a very, very powerful document. Ordinarily, under a power of attorney, you appoint somebody you trust, hopefully, to deal with your property and your finances as if they were you. Effectively, your attorney is somebody who can go to the bank, operate your bank account, buy and sell property in your name, deal with your superannuation. As I tell people, your attorney can effectively go to the bank, take your money, sell your house, get the proceeds of sale, deal with your superannuation, and skip with the proceeds to Brazil. Very, very powerful documents. You only ever appoint somebody that you trust will do the right thing. So spouses ordinarily, hopefully, trust each other, and they're a common person that they appoint. So husbands appoint wives, wives appoint husbands, and the like. The question is, where do you go to next if your spouse has passed or has become incapable of dealing with the estate? People look to kids. Sometimes there's a concern if the kids are too young, or if children have their own financial concerns, or simply if they're not trustworthy. As I said, these are powerful documents. Whoever your attorney is can do some amazing things with your property without your say-so and without anybody standing over their shoulder looking at what it is that they're doing. So you need, it doesn't matter what the law says, because the law does say that they've got to act in your best interest, but the law also says that people aren't allowed to rob banks. So you need to trust whomever it is that's appointed that they will do the right thing. Now, if you appoint your children, you can appoint more than one person. You can appoint them to act jointly, which means that both of them must act together, or they can be appointed jointly and severally, which means either of them may act. So there are certain checks and balances. A lot of people like the idea of a joint appointment. It means that nothing can happen without both, or more than one, or more than two, agreeing. But there's also a logistical issue that you need to factor in, which of course is that these days, children are scattered far and wide around the world. They may not necessarily be in the location that you need them to be to sign documents quickly. But having said that, in this day and age, audio-visual equipment, electronic signing, all those sorts of things are becoming more prevalent. And the government's actually changed the law to facilitate a lot of that stuff as well. So you need to think through the logistics as well as the checks and balances. If you appoint joint and several, then even though only one person needs to sign, the others have the ability to obtain information. They can speak to the bank, they can speak to the lawyer, speak to the accountant, obtain the information that they need to keep an eye on what the person signing may actually be doing. So in that sense, it may not be to the sign, which provides the comfort that you're looking for, but it does at least allow others to find out what's going on. So that's power of attorney. I should add that you can also make a power of attorney effective from any particular point in time that you choose. It can be immediately your attorneys accept their appointment, or it can be, for example, when a doctor certifies that you've lost capacity. And it only becomes effective when the doctor provides that certificate. Now, I'll move from there to enduring guardian. Now, an enduring guardian is somebody who, if because of disability you're unable to make decisions for yourself, can decide where you live, what healthcare you receive, personal services and medical treatment. They can also make decisions about end of life. So again, very, very powerful decision-making capacity. Why would you have this document? Well, in this day and age, hospitals are becoming increasingly concerned about litigation. They want to make sure that they're getting instructions from somebody who is authorised to actually give those directions. Also, if they're called upon to share information, they want to make sure they're giving it to somebody who is entitled to receive that information. And guardianship documents permit all of that. So if because of disability you can't make decisions, then your guardian is empowered to do so. The critical thing here is, again, a practical issue, and that is making sure that your guardian understands exactly what your wishes are, and you have the faith in them that they will carry out your wishes. To assist in that, I encourage people to have a conversation. Obviously, you need to have the conversation, need to make sure that they understand what you want. In addition, you may have heard of a thing called an Advanced Care Directive. So this is a document whereby you set out what your wishes might be. Your GP has those sorts of documents available, and you can ask for them to assist you in filling out that particular document. We also provide documents that effectively can say things like, especially dealing with end of life, that we want dignity preserved, we want pain treated, but otherwise, if I'm at a terminal stage with no prospect of recovery, let me go. So they're the sorts of things that people might want to contemplate. One thing that I might now turn to, and we'll have some questions as well, but is the issue of provision and challenging wills. So in the beginning I said why we need a will, and then I will generally have a chat with people and they'll ask me, so son A has really annoyed me. They've been estranged from me for the last 30 years. They've never contacted, never rung at birthdays, never sent Christmas cards or anything else like that, and I don't want to provide them anything. Can I give them $10,000 or $1 and preclude them from making any claim on my estate? And the answer to that is no. It doesn't matter what you give somebody, if they think it's inadequate, having regard to their circumstances, they are entitled to make a claim for provision. Now, whilst they might be able to make a claim if they're part of the list of eligible persons, and children certainly are, getting an award from the court is a different matter. So whilst a person can make a claim, and there's a process that they need to go through in order to have that claim determined, which includes mediation, what we're seeing increasingly these days is that courts are upholding the will of the testator. Courts are increasingly looking at the circumstances of the testator's intentions and trying to give effect to it. That's not to say that all wills are being upheld, but what we're seeing is it's not a case anymore of every kitty getting a prize. So if you have got a situation where you're clear that there is somebody in your life who might otherwise have a claim for provision, and you want to ensure that not them, but somebody else is preferred, then there are steps that we can take to ensure that the court is aware of your intentions, the reasons for that, which the court then takes into account. And as I said, increasingly the courts are refusing to make awards for people just because they're a child. So I suppose with that, I'd like to wrap up, but I will suggest that if you have any further queries or questions about this particular subject, then please go to our website, Donovan Oates Hannaford Lawyers, and download the free Wills and Estate Guide that we have there. It can be a helpful primary source, and then of course if you have any further questions, we're sitting here ready, willing and able to assist.
Just on that, Hadyn, we do have a couple of questions that have come in prior to the live session, and one of those in relation to wills was, I don't want my son's wife getting the inheritance. What can I do? Well,
it sounds like that might be a situation where perhaps the son and the wife aren't necessarily on strong terms in the matrimonially, but the wife is not necessarily going to receive anything anyway. So you make provision for your son, the son receives. The issue that you might face is that in due course, what you've provided to your son will become part of the matrimonial property. And if it's just a straight gift to the son, then there's very little that can be done to avoid that over time being taken into account, for example, by the family court if there's an issue down the track. But a testamentary trust might be an appropriate vehicle in something like that. And I mentioned that earlier, whereby the son doesn't actually have what's called a vested interest in the share of the estate. There's a testamentary trust, it's a discretionary trust, and the son forms only a class of entitled beneficiaries. And structures can be put in place so that you actually are there providing for your son, but in the matrimonial, in the family court proceedings, the wife cannot say that that is actually the son's property because it's held by trustees, and the son doesn't have a vested interest in that property.
There's one, it's a little bit different, but my husband and I have been married before and have children from other relationships. I want my husband to have everything if I go first, but then for my share to go to my children after he goes. How can I make sure my children don't miss out if he changes his will?
Right, okay. So this is increasingly becoming an issue in today's world. We've got many situations where people are married more than once, and the second time round have children from earlier relationships. They can be very long-standing. The issue that a lot of people ask me is, well, we're still reasonably young. If something was to happen to one of us, the husband, for example, might remarry, and the next wife comes along, and if I give everything to my husband, then the next wife might get everything. So it can be quite a tricky situation. You want to be able to provide for your children, and there are things that can be put in place. Obviously, I don't understand everybody's circumstances intimately. This is only a sort of a general indication of what's available, but it would need an examination of individual circumstances to determine what the best course is. There can be things like giving a life interest in assets, providing income to somebody, preserving the capital for others. There can be things called mutual will agreements entered into that basically say that each of you, husband and wife, agree that when the first of you goes, your estate must go in accordance with the terms of will that you have agreed between you. Generally, that provides, for example, that your spouse can get everything, but then when they die, their estate must be distributed in accordance with your agreement. So, if you've got two kids from each prior relationship, then the estate could be shared equally or shared on some other basis between those kids. So there are structures, but it would require an investigation into personal circumstances before determining what's the best thing for you.
Hayden, there's one in relation to life documents, and that is, my husband's been diagnosed with dementia. Can he still exercise and appoint through life documents?
Yeah, no, this is increasingly also a very interesting issue. So as we age, it's recognised that our mental capacity can suffer. And it's quite common that people will attend on me with a diagnosis of some form of dementia. A diagnosis of dementia does not necessarily mean that they lack the relevant capacity in this particular circumstance to make a power of attorney or appointment of enduring guardian, but it also doesn't necessarily preclude them making a will either. There are tests that the courts have enunciated to determine whether somebody has capacity. Medical diagnosis is an element of all of that, but at the end of the day, the courts have been clear that it is up to the solicitor taking the instructions to determine whether or not the person has capacity, whether they are coherent, whether they understand the nature of their estate, the people to whom they should have regard, whether or not they're being subject to some sort of influence, and if so, separating them from that influence. So at the end of the day, a diagnosis of dementia is not determinative. It's not the end of the story. It does, however, cause a solicitor to actually make further inquiry, and it may be necessary also to send them off, a person off to a doctor for some further investigation. But at the end of the day, it remains the solicitor's call.
Hadyn, I've got two more questions. One's in relation to power of attorney, and that is, what happens if I don't like what my attorney is doing? What can I do then?
Well, your attorney is always charged with duties to act in your best interests. So, and they must, while you have capacity, act in accordance with your direction. So, to the extent that you direct them to do something and they refuse, then you've got grounds to revoke their appointment and probably have some sort of claims against them as well. But effectively, your attorney must act in your best interests, and if you provide them with the direction and they fail to act in accordance with the direction or whatever, then there may be some other rights. If you've got capacity to appoint an attorney, you also have the capacity to revoke that power, and you can terminate that power.
And the last one that we have is in relation to the appointment of an enduring guardian. I don't want to go into aged care. I want to die at home. Can my guardian make me go?
Yeah, it's an interesting question. It's a sad issue too. Many people, they've lived in a house for a long time. They have very fond memories. They don't want to go into aged care. They have a fear of that, and understandably, so. However, sometimes there's a point that's reached where care can't be provided at home. Now, the enduring guardian only has power if you lose capacity to make decisions for yourself because of disability. So it's only in those circumstances when the enduring guardian actually has the ability to make those sorts of decisions. They're obliged, as I said, to carry out your wishes, but obviously those wishes may not become feasible. So if at a point in time where you've lost capacity and where it's no longer feasible to be cared for at home, then yes, your enduring guardian can make decisions to that weren't necessarily in accordance with what your wishes were at the beginning. Now, there are review mechanisms available, and if somebody is dissatisfied with the way either an attorney or a guardian is carrying out their functions, then in New South Wales we can go to NCAT, the New South Wales Civil and Administrative Tribunal Guardianship Division, and seek a review of the operation and effect of a power of attorney or appointment of enduring guardian, for example. So if they're the last questions, then I might close this up. But again, thank you for tuning in. Again, my name's Hadyn Oriti from Donovan Oates Hannaford. Go to the website, download the Wills and Estate Guide. I'm sure you'll get value for money out of that. Obviously, it's free. Thank you.